all rise.
Thank you. Please be seated. Morning, everyone.
Good morning.
This is CV 2022-01468, in the matter of Gene Kinch, Ted Boyd, Abraham Hamadeh, the Republican National Committee versus Chris Mays, Katie Hobbs, etc. Defendants show the presence of multiple parties. Show the presence of Mr. Lasota, who's representing the plaintiffs in this matter. Show the presence of Mr. Lokowski and Mr. Warrington. I believe they're here. I haven't seen them yet. Well, there's Mr. Lokowski, representing the plaintiffs of Pro Hoc Vice. I haven't seen that yet, but they're coming. This is your clients here, Mr. Lasota?
Yes, Your Honor. We have Mr. Boyd. He's on the Zoom. We have I have Mr. Hamadeh here in the room with me, and I believe we have Ms. Kench as well, but I don't see her. Yeah, she's on the call, Your Honor.
All right. Thank you, Mr. Lasota. Show the presence of Ms. Duell representing the Secretary of State, Ms. Hobbs. Is Mr. Barr with you too as well?
Yes, Your Honor, here representing Chris Mays.
All right. So the president, show the president representing Ms. Mays. So the presence of Dan Barr representing Chris Mays. Do you have Ms. Donovan with you and other parties as well, Mr. Barr?
I'm sorry, Ms. Mays is not here, Your Honor, but with me is Alexis Daneman, Austin Yost, Samantha Burke, Reagan Jensen, and Matthew Corner.
All right. Some of those names sound familiar, including one of the inspectors. Show the presence of Ms. Duell for Ms. Hobbs. Who do you have with you today, Ms. Duell?
Your Honor, I have Andy Gaona, co-counsel.
Okay, Mr. Gaona, I see you now. You weren't here yesterday. I apologize. Mr. Gaona, show the presence of Mr. Gaona. Ms. Duell, we had a big echo from yours, so hopefully that's not a problem with other people as we go forward. Mr. Gaona, who do you have with you today?
Your Honor, Ms. Duell and I are in the same room. It's just the two of us on behalf of the Secretary.
And that may be why the echo. So if we can make sure one of you is muted while the other one's talking, but we did not have an echo from your computer, Mr. Gaona, and I'm assuming you'll be the lead counsel today. I'm assuming I have Jason Moore. There's Jason Moore from Navajo County, representing Navajo County. I have Mohave County Attorney's Office show the presence of Mr. LaRue, Ms. Krieger down there. Mr. Esplin is here in the courtroom from the Mohave County Attorney's Office, and I assume I have several other county attorney representatives representing their counties today, mostly in a nominal role. Is there somebody from Pima County, Mr. Jerkowitz? There you are.
Good morning, Your Honor.
So the presence of Mr. Jerkowitz. Mr. Esplin wanted to put some, before we have any other preliminary matters, Mr. Esplin, you wanted to put something briefly on the record?
Yes, Your Honor. We just, in the interest of transparency, and we want to make sure that the court is, that all the parties are aware. Just there was an ex parte communication with the court on the December 21st, and it was regarding the 16677, the inspector and appointment of inspector. The court had inquired of counsel, how do we find this inspector, and so there was just a brief discussion about that. And, how do we do this and then go from there? And so we would just want to make sure that the parties are aware that we had that discussion, and the court can elaborate further if the court wishes. But that was just we just want to make sure we're aware that there was just a couple conversations back and forth about how does that work? How does the court appoint someone? And I sent an email to the court saying, well, this is how Maricopa County does it, and this is how the Maricopa County cases were proceeding. So I just want to put that on the record that there was just a couple of conversations with us in the court about that. And so make sure all the parties are aware that that took place, and in the interest of transparency so that everyone is aware of it.
All right. Thank you, Mr. Esplin. I guess I didn't, I appreciate the thing. As you guys know, 16377 is a specific statute I had seen in one of the orders that had been sent to me by the parties that Judge Thomason had had the local Maricopa County Attorney's Office prepare get someone that could serve as an inspector. So I just contacted the county attorney's office, said if I made that order of the Mohave County Attorney's Office, would they be able to find an inspector? So I hope that wasn't improper. I don't believe it was improper. And so thank you for making the record on that. Mr. Lasota, are there any other preliminary matters before we get started today?
Your Honor, there is. This is Joe LaRue for Maricopa County. We have several attorneys on this case, and Karen Hartman-Tejas is stuck in your waiting room at the moment. Oh, is she in now? My apology, Your Honor. Last time I knew she was in the waiting room. But appearing today for the county, in addition to myself and Ms. Krager, we do have Karen Hartman-Tejas. We have Joseph Branco, Rosa Aguilar, and Jack O'Connor.
So who's going to be doing the questioning or the speaking? I do want to try to not limit. I mean, I guess we have a full day scheduled for this hearing and we need to get through it, but I'm just about to ask for opening statements. And I guess if I'm going to get 7 of them, it's going to be a long day. I'm hoping that we're limiting who's speaking and we can and get moving forward to the evidence. I did mention at the end of the last hearing that I'll be very liberal about getting the evidence into the record so that we can argue what the parties believe is important. I did receive a couple of things overnight. I received from the Mays defendant and the Hobbs defendants trial briefs, memorandum briefs. I also received a motion from Mr. Lasota to grant an order that some of the inspected ballots be released. There didn't appear to be any opposition to that order in the motion, and so I've granted that. I didn't have a signed order, but I put something out granting that. So the ballots that were inspected that you wanted to get.
Your Honor, I need to be heard on that if the court already granted that motion.
All right, Mr. Jerkowitz, go ahead.
In Pima County, we did the inspection according to the court's order yesterday. There were no inaccuracies found on any single ballot that were pulled by the inspection team. Those ballots have now all been packed away and they're being inventoried for transfer to the treasurer's office this morning. I would very much strongly object to any of those ballots being pulled out yet a second time for no reason to be transported somewhere.
I guess,
Your Honor, may I interject? We're not. Our side is not asking Pima County for any of their ballots to be produced to the court.
Okay, and that's the impression I had as well. It was only ones that they had some questions about. So if that's what happened in Pima County, then there wouldn't be any of those ballots released. And that's all that I ordered, and I hope that's all that was the understanding of the request. And I thought there would be no serious objection to it, and I would grant the request over objection to ballots that they would show me that may have been different or difficult to read. So hopefully we're going to get somewhere with that. Mr. Lasota, let's get started.
Your Honor, I'm sorry. Before Mr. Lasota starts, Joe LaRue again. I just want to be clear. Your Honor did order the ballots to be produced, to be entered as exhibits. Is that correct?
I ordered that the ones that the plaintiff is requesting to show the court that there may have been, that were done in inspections, they want to show me why I should consider them to be released. And I got the impression that you didn't have any objection to that, Mr.
No, Your Honor, we do not. I just wanted to be sure that was the court's order. We needed Your Honor to order that before we could do it. So we will direct our people to email the link to Mr. Lasota so that he can upload those or do with them as he needs. We simply ask that they be kept under seal and that they not be shown to the public.
All right. Again, I didn't have a written order to do that, but it is ordered that they be kept under seal.
Thank you, Your Honor.
All right. So let's get started. Mr. Lasota, do you have an opening statement?
Well, Your Honor, I in terms of the actual ballots, our inspectors looked at them. We would ask that there be a stipulation that any ballots that any party wants admitted be admitted to this court. But in terms of, and that's really, and we're going to ask the court for a ruling on the ballots that are submitted as exhibits or are admitted as exhibits, I should say. But obviously, we've not, because the county believed that they had to get the court order before they could share those. We haven't been able to upload those into the portal. We can do that, but in terms of I'm hoping we can stipulate that those are admitted. There aren't a lot of them. I think that Chris Mays' side wanted 6 or 8, and we wanted 6. And we're hoping Your Honor could make a ruling on how those ballots fall out in terms of if there's erroneous ballots, that you would rule on that issue. The other thing is that we also, in terms of where we're going today, is in terms of our evidence, that is going to be all we submit. We are going to renew our petition to inspect more ballots. We do think that it's a relatively small sample size in the undervotes. We did see a trend in favor of Mr. Hamadeh, as we suspected. It's not, it's not a monumental trend. I'm not suggesting that. I think Mr. Hamadeh picked up 6 votes, Ms. Mays picked up 2. And that is the undervotes. I think the other side might have something to say on the adjudications that were inspected. But, we think the sample size is small. We understand Your Honor has already ruled on this, but we just would renew our petition for those ballots for further inspections. We'd also renew the motion for expedited discovery. We understand Your Honor's already ruled on that as well. And that's about it. Right now, we have not, we're just getting those ballots now. So I don't have, I would like to upload those and then if, I guess I'd ask the other side, I know this is a little unorthodox, if they will stipulate to admission of those ballots. And if not, then I'll call maybe I don't know if the county inspector's on. I do have Heidi Grande, who was our inspector, who can lay foundation for those ballots.
Mr. Barr, I'll start with you. Do you stipulate to the admission of these ballots? And I can do with them, use them for what they're worth and review them? Mr. Barr?
Sorry, Your Honor, I have to unmute myself. Yes, we will stipulate to that.
Mr. Gaona?
Your Honor, the Secretary takes no position on this issue, subject, of course, to the limitation mentioned by Mr. LaRue that the ballot images not be broadcast to the public.
And Mr. LaRue?
Yes, Your Honor, that's fine with us.
These don't sound like they're from anywhere else except Maricopa County. Is that right, Mr. Lasota?
That's correct, Your Honor.
Your Honor, this is Jason Ward, Navajo County. I think that some of our ballot images were requested too, and pursuant to the court order and consistent with the limitations that the court's mentioned on making those public. We have we're working right now on sending 9 ballot images to Mr. Lasota, and his firm can take care of filing those with or uploading those to the portal.
Okay.
Your Honor, maybe one of the other parties wants the Navajo ballots, and we would obviously stipulate to admission of those, but I'm not requesting that.
Yeah, we're not requesting them either, Your Honor.
Or maybe we don't even need to do that, it sounds like. If the plaintiff's not requesting them, this is the plaintiff's day. This is the plaintiff's burden today to prove the elements. And obviously, I guess, Mr. Lasota, you just, I'm trying to figure out what you just told me. It's like that's the evidence that you're going to present today, and then you want to argue the case. The state, the counties and the other defendants who need not produce any evidence, they have a right to produce evidence if they want to. So is that where we are at today? The court is admitting, pursuant to stipulation by all the relevant parties, to the ballots that are being requested by Mr. Lasota from Maricopa County, and it is when they get uploaded, it is ordered that they be sealed. They're not to be given to the public. and shown to the public, but we'll address what's important in them for me to consider in determining whether or not the plaintiff is meeting their burden today. And are there any other witnesses or evidence that you want to call, or you just want to argue that later on?
Yes, Your Honor. I essentially just want to make the points I've made with regard to the further inspection and the I made those points. I know you've ruled already, but and those ballots are admitted. We do think they show a trend. So I will just, I'd obviously ask to be heard after the other side, but that's all I have. And I think it's over to them at this point.
All right. So, Mr. Barr, I expected I was coming to you to make an opening statement of some sort. It sounds like it's more of
I do have a short opening, Your Honor, and then I'll have a question that maybe we can resolve with plaintiffs. Your Honor, for 2 weeks after they filed their verified complaint in this court, based solely on information and belief, plaintiffs had no facts to support any of their claims in this case. Yesterday, plaintiffs spent the day looking for facts in Maricopa County, Pima County, and Navajo County. They are the ones who chose where to look for the facts. They are the ones who chose the ballots in these counties. The evidence will show that of the thousands of ballots that plaintiffs reviewed yesterday, they found a total of approximately 4 ballots that were undervotes in the Attorney General's race that arguably should have been adjudicated differently. In Pima County, as Mr. Jerkowitz has said, they found 0 ballots that would support their claim. In Navajo County, they arguably found 1, which was a vote that may have been for an unnamed write-in candidate that was tabulated for Chris Mays. In Maricopa County, they found 3 ballots, which under further review should have been tabulated for Chris Mays. So that's it, Your Honor. 4 ballots in 3 counties, the results of which Chris Mays netted 2 additional votes. The only question that remains after yesterday's review of the ballots that plaintiffs selected is why we're even here today. Plaintiff's case was in better shape, frankly, yesterday morning when they had no facts than it is today. The evidence will show that the only truly admissible evidence is the firsthand information that plaintiffs possess that in the 2022 election for Attorney General is that Chris Mays arguably netted 2 additional votes. And with that, Your Honor, I need to clarify with the plaintiffs what exactly we're doing today now. It seems like they've abandoned counts 1 through 3 of their complaint, and that they're only seeking to prove evidence of an erroneous count. Is that correct?
I'll get that.
If it's okay, I could address that, Your Honor. We're not abandoning those counts. We are. I would say that we do not have further evidence to offer, and we've obviously made our record on the motion for expedited discovery and petition for further inspection of ballots. So I mean that's a mischaracterization to say that we're abandoning any counts.
Well, Your Honor, I'd like to know what proof they're going to put on today regarding counts 1 through 3.
They've already said what proof they're going to put on today, and that's going to be the ballot. So they're going to live with the proof that they have alleged in the petition. Is that correct, Mr. Lasota?
Yes, we have produced what proof we can offer today.
All right, thank you, Mr. Gaona.
Your Honor, I will not be repetitive of anything that Mr. Barr said. I want to be respectful of the court's time. We were here. I'm sorry, can you hear me, Your Honor?
Yeah, I said it sounds like I'm going to have more time than I thought this morning.
I think that's right, Your Honor, and that would be great for all of us going into a holiday weekend, I'm sure. Just a few words, Your Honor, which is that we were here what seems like weeks ago, but was just a few days ago. and told this court that the plaintiffs had no evidence to support their claims and that they should have been dismissed. And as Mr. Barr put it, that we should not be here today. Those predictions turned out to be rather prescient. We are here on a serious matter. Mr. Hamadeh has asked this court to overturn the results of the election. They had no proof when they filed their complaint. They have no proof now. And the defendants will be putting on some evidence, Your Honor, to establish the processes, what happened here, and why the court has absolutely no basis to overturn the election. And we look forward to the prompt dismissal of this case and the confirmation of Attorney General-elect Mays as the Attorney General. Thank you, Your Honor.
All right, thank you, Mr. Gaona. Mr. LaRue, opening.
Your Honor, no opening, but a request. We had anticipated that plaintiffs would put on their case in chief first, and that the ballots that Mr. Lasota wants to use as evidence would be already either in evidence, stipulated to as we did, but they would be uploaded and available. That hasn't happened yet. We just now emailed to Mr. Lasota the link containing the ballots. So I would ask that we take a 10-minute or 15-minute recess to allow him to upload those to the court's portal, because our first witness will be Mr. Scott Jarrett, who is our co-elections director. And Mr. Jarrett will walk through the ballots and explain the county's processes and why the county made the decisions it made with regard to the adjudication of those ballots. We believe that would be helpful to the court.
All right. You think that can be done in 15 to 20 minutes, Mr. Lasota, maybe shorter?
Your Honor, I've never used the Mohave County portal, but we're not talking a lot of material, so I think it'll be quick.
All right.
And Your Honor, could we also ask the county to send the ballot images to the Secretary's Council subject to the court's sealing order, and we of course will not disseminate them beyond council, just so we can all look at the documents at the same time.
And counsel for Chris Mays would ask the same, Your Honor.
All right. Obviously, Mr. LaRue, if you can make that happen. And everybody has to follow the same order. These are sealed. I would just say everybody that's on, we're going to take a 10 to 15-minute break, however long it takes. If somebody will let somebody know, I'll be just waiting in the back to come back in here and start up with that during the break. So I'm going to just stand at recess for as short a time as possible. Let's make that happen.
Laws exist in order to seek justice.
It looks like we have everybody back. We're back on the record in CV 2022-01468. I did note while we were off the record that 14 new exhibits have been admitted under the plaintiff's exhibit numbers into the digital case line. It is ordered pursuant to the stipulation prior to the break. It is ordered admitting plaintiff's exhibits 1 through 14, all inclusive, as evidence for the court to consider in this matter. It is further ordered that these documents be sealed. This is private ballots that should not be made available to the public, but the court will review them and give them proper consideration. This is the continuation of this hearing. Mr. Lasota, do you have any other evidence to admit?
Your Honor, the only other thing I think is that, you do have the ballots, but you don't really have an explanation of how they were originally counted. And I could call Heidi Grande to just state the undervotes we found for Mr. Hamadeh. Obviously, there are ballots for Ms. Mays also, but I would just leave that to them because I saw these for the first time just now. I have my 6 essentially by ballot number that's the only thing I'd like to point out to the court is which 6 that we would like you to look at, and then how they were originally scored in terms of how they were counted originally, because that will give you the baseline, and obviously the other side is probably going to want to do the same thing. Otherwise, you may not know, well, why is he asking me to look at this ballot? Unless we could all just stipulate that, how it was counted initially.
I guess I was hoping to hear evidence about how many ballots were inspected and why these particular ballots were culled out for the court to review.
Yeah, if you want, we can call, I think we have Heidi Grande on the line.
Mr. Lasota, it's what you want. This is your case.
Okay.
It is calling Heidi Grande as a witness?
Yes.
All right, Ms. Grande, are you on the Zoom so we can all see you?
Yes, I am.
All right, can we bring her online? Can you talk again, Ms. Grande? You popped up for a
Yes,
second.
I'm here. It's saying host has denied video or stop video.
Yeah, we can, the host will undo that here in a second. Did you find her?
Did you make sure we have the
Right.
numbers? Those are the numbers I have.
All right, so we're going to there you are, Ms. Grande. Okay, Ms. Grande, raise your right hand. The clerk's going to swear you in as a witness.
Do you solemnly swear or affirm that the testimony which you shall give in the cause now pending shall be the truth, the whole truth, and nothing but the truth, under penalty of perjury, so help you God?
I do.
All right, go ahead, Mr. Lasota.
Thank you, Your Honor.
Mr. Lasota, I am sorry for interrupting. Your Honor, I am very sorry for interrupting. But it's my understanding that media is on, and if Mr. Lasota brings up these valid images, they will be viewed. I just want to flag that for Your Honor. I don't know how to handle that.
Do we have a way to just show them to the witness and not and to the court and not to the public?
As long as the witness has case lines, an instance of case lines up on their computer, and Mr. Lasota can have them accessing that and being able to reference them and show them. But if we share a screen here on Zoom right now, it is going to go to the public.
All right, so, and I'm assuming, Ms. Grande, you don't have case lines on your computer, or maybe you do.
Case lines as in?
Our digital evidence system that we have here in the county.
No, sir, I do not.
Your Honor, I think we can just point these out by ballot number.
Without showing them?
Yeah, without showing them, because she knows which ones that, she wrote down the numbers, and I think it will be pretty apparent to Your Honor what we're talking about if you do look at the ballot specifically. But as long as you have essentially the last 6 digits on the ballot image, and they're all given a lengthy number. But as long as you have as long as everybody has the number, we can just explain to you what we'd like you to look at.
Right, and just for the record, I can access case lines separate from Zoom, and I can do that while you're talking about specific ballots as well.
Okay.
So go ahead.
Thank you, Your Honor. Good morning, Ms. Grande.
Good morning.
So you've stated your name for the record. Will you just give us a little background about yourself?
I'm sorry?
What do you do?
Currently working for the AZGOP.
Okay, and you were one of the court-appointed inspectors in Maricopa County yesterday?
That's correct.
Do you know how many ballots you looked at?
We approximately went through about 2,000 and we hit I think about 2,600.
Well, was it, which is it, 2,000 or 2,600?
Closer to 2,600.
Okay. Do you know what the composition of those ballots was?
Composition as in how many were?
Were they undervotes? Were they adjudications?
They were all undervotes and some were adjudication.
Okay. Do you know how many adjudications?
Adjudication totals went through, I believe that was 120 or 106, sorry.
Okay. So the rest were undervotes. Is that correct?
That's correct. Yes.
Okay. Now, in terms of the undervotes, and I know you found you found different things, but you did find some actual mistakes, correct?
That's correct. Yes.
Okay. And in fairness, not all the mistakes favored Mr. Hamadeh.
That's correct.
Okay.
Yes.
So in terms of the undervotes that you examined, could you just tell the court what you found?
What I had found in the undervotes was that the 4 that I had identified, they did favor Mr. Hamadeh, but then they went to the original read, and then went to adjudication. Adjudication also disagreed and they found it as blank. And that's what it shows in adjudication.
Okay. Can you give us the ballot numbers you found for Mr. Hamadeh?
Yes. First one, do you want the full number or the last?
I think the last 6 digits will suffice.
Okay, so it's 000084.
Okay.
000410.
Okay.
00054. And then there's 2 with the same last digits. So do you want the full number?
Yeah, if you could give the full number for those, that'd be good.
07008 00063 000142 07009 00007 000142.
Okay. Maybe I can just repeat those just so that we have all those. The first was 07 0008 0006 3 and then 000142. Is that correct?
Yes, that's correct.
Okay. And the next one is 07009 00007 000142. Is that correct?
Correct.
Okay. And was there one more?
There was one more here, which is 04. Well, actually, we can go with the last digits on this one.
Yeah.
It's a lot easier. 000711.
Okay. Very good.
Your Honor, and Mr. Lasota, I'm sorry, Your Honor. We had just printed out the copies of the ballots. And I just want to make sure we're all looking at the same number. So, can we get some clarification on where the witness is pulling the number from, so we're all looking at the same thing?
What I have here was what we pulled yesterday when we were inspecting ballots, all of which was given over to Scott Jared to pull for the court.
And they all have a unique number, correct, Ms. Grande?
That's correct. They all have a unique number.
Mr. Gaona, did that help?
Well, I'm just trying to figure. I'm looking, Mr. Lasota, at the full printout of each of the ballots that were just uploaded. And
Your
Is
Honor.
it only on the electronic file name that you can see the number? Is that what it is?
Yes,
I see.
Yes.
yeah,
Yes.
so I actually don't have them printed out. I'm just looking at them as they're identified on the electronic exhibit. So
Okay.
if you look at that, that will tell you the number.
Okay, understood. Thank you very much for the clarification.
If I
You got
can, if I can just help a little bit, maybe, I've written down each of these numbers and then corresponded them with the exhibit numbers that, we'll be looking at. 00084 is exhibit 6. 000410 is exhibit 7. 00054 is exhibit 8. 000711 is exhibit 9. The first 142 that begins in 07008 is exhibit 11, and the second 142 that begins in 07009 is exhibit 14. So those are the exhibit numbers.
Thank you, Your Honor. So it sounds like we're talking about exhibits 6, 7, 8, 9, 11, and 14.
Correct.
Okay. All right. So those are the ballots. Now, Ms. Grande, would you just explain, those were originally counted as no vote for any candidate?
That's
Is that
correct.
accurate? Okay.
Yes.
But the ballots show that those should have been voted, so that's an undervote, correct?
That's correct.
Okay. But the ballots clearly show that those votes should have been for Mr. Hamadeh, correct?
That's correct.
Okay. I don't have anything else for this witness, Your Honor.
All right, thank you. Any questions? I'll start with Mr. LaRue.
Yes, Your Honor, thank you. Good morning, Ms. Is it Grande?
Yes, it is. Or it's Grandy, but
Grandy. Good morning,
you.
Ms. Grandy.
good morning.
And I want to thank you again for being present yesterday and being part of the inspection. As I told you yesterday, that is an important process, and everybody appreciates your participation. I have just a few questions for you. Have you ever received the Secretary of State's election officer certification training?
No, sir.
So you aren't an Arizona elections officer?
No, I'm not.
Okay. Are you an elections officer in any state?
No.
Have you ever been part of an adjudication board in Maricopa County?
No.
Have you ever been part of an adjudication board anywhere?
No.
Have you ever received any training in adjudication processes by Maricopa County?
Not by Maricopa County.
Have you ever received any such training anywhere in Arizona by a county?
Not by a county.
No further questions, Your Honor.
Thank you, Mr. Gaona. Any questions?
Your Honor, just one.
All right, we'll
Just
switch.
one question, Your Honor. Sorry about that.
Ms. Duell, go ahead.
Ms. Grande, just one question for you. Are you familiar with the Arizona Secretary of State's voter intent guide? You know what that is?
Voter intent as to what the adjudicators.
No, that's the Arizona Secretary of State's office has a voter intent guide. Are you familiar with that? Have you ever read it?
I have seen the guide.
Can you tell me, describe generally what that document is?
Objection as to relevance, Your Honor. These didn't go to adjudication.
Your Honor, this is relevant.
Question if she knows, and so the objection is overruled. Go
Answer.
ahead. Tell her what you know, Ms. Grande.
Yes, I have seen documents as to examples as to what would be considered a vote, undervote, overvote, etc.
When did you see that? Or
I saw
where-
that actually yesterday.
You saw it yesterday?
Yes.
Did someone at the county give it to you?
No.
Where did you get the document?
I actually got it via email, and let me pull up. Let me one moment. This is the Maricopa adjudication quick reference, and I can give you the number. This is in the adjudication quick reference guide. Did you want the number to the page?
Sure, yes.
That's 102-42-020.
As you're looking at that document, Ms. Grande, is that, I was asking about the Arizona Secretary of State voter intent guide, and it sounds like that document is the Maricopa County one. Is that correct?
Maricopa County adjudication, yes.
Okay, so that document that's in front of you that you're referring to when you said that you had seen the Secretary of State's voter intent guide, you're referring to this document that's actually the Maricopa County adjudication quick reference guide. Is that correct?
That is correct.
Okay, no further questions, Your Honor.
All right, thank you. Mr. Barr, any questions? You're on mute, Mr. Barr.
Yes, Your Honor, just a few. Ms. Grande, I'm sorry, it's Grande?
Grandy.
I'm sorry.
That's okay.
You were part of a 3-person panel that reviewed the votes, the ballots in Maricopa County yesterday, is that correct?
That's correct.
And the members were Reagan Jensen, correct?
Yes.
And Christina Worth, is that correct?
Was the attorney
Yes.
present? Yes.
Yes, and she was the court-appointed one, correct?
Yes.
And the 3 of you reviewed the ballots and determined whether you agreed or disagreed with determinations, is that correct?
That is correct, and we were in agreement upon the ones we were actually putting into exhibit.
And well, that isn't so, is it? Is that in fact you disagreed, the other 2 disagreed with your determinations regarding Exhibit 11 and Exhibit 14, isn't that correct?
I can't see that ballot, so I don't know.
Well, would you agree that they disagreed with some of your determinations yesterday?
There was one in disagreement.
Okay, and if somebody testified there was more than one, would they be telling the truth?
That there was more than one?
Yes.
Yes.
Okay. In fact, there were they also made determinations that you disagreed with concerning ballots that should have been counted for Chris Mays, correct?
I agreed that it should have gone to adjudication.
But you disagreed with what the adjudication results should have been, correct?
It was not adjudicated, so I did not agree with that. That's correct.
So my question is simple, Ms. Grante, isn't it true that the other 2 members of this panel disagreed with several of your conclusions regarding whether votes should have been counted yesterday?
Not several I won't agree with.
Okay. I don't have any further questions, Your Honor.
All right, thank you. Anything else? And unless somebody else jumps in, I'm going to go back to Mr. Lasota at this point. Mr. Lasota, any further questions for Ms. Grande?
No, I don't have anything, Your Honor. Thank you, Ms. Grande.
Andy, thank you for testifying. Mr. Lasota, call your next witness.
We don't have any other witnesses, Your Honor.
All right. Who wants to go first on the other side? Mr. LaRue?
Yes, Your Honor. Maricopa County will call Scott Jarrett.
All right, we're going to find Scott Jarrett. Get him up on video Zoom.
He's in the room. Your Honor, he's in the room with us. He's in the room. He's coming right now.
Okay. All right, and with you getting up, Mr. LaRue, I assume Ms. Krieger is going to be doing the questioning?
That's correct,
Your Honor. Thank you.
All right, so Ms. Krieger, you're calling Scott Jarrett. Mr. Jarrett, please raise your right hand. The clerk's going to swear you in.
Do you solemnly swear or affirm that the testimony which you shall give in the cause now pending shall be the truth, the whole truth, and nothing but the truth, under penalty of perjury, so help you God?
I do.
All right, you can be seated. Go ahead. All right.
Thank you, Your Honor. Please state your name.
I'm Robert Scott Jarrett.
And where do you currently work?
I work for the Maricopa County Elections Department.
And what is your current position?
I am the co-elections director, and I oversee all in-person voting operations. That includes early in-person voting, which report up to the Maricopa County Recorder, as well as election day in-person voting operations, which report up to the Maricopa County Board of Supervisors, as well as I oversee all tabulation functions.
And how long have you held this position?
So I was appointed by the Board of Supervisors in June of 2019.
Just briefly describe what your job duties are in this position.
So I oversee all in-person voting operations. So that includes the recruitment and training of all of our poll workers, also the recruitment of all of our temporary workers that work at McTech. I also oversee all of our warehouse functions. I oversee the tabulation function as well, which would include the hiring of the temporary staff that work in tabulation, as well as the training that occurs for our temporary staff, which would include our duplication and our adjudication boards.
And what did you do before you were the director of the co-director of elections?
So I was with Maricopa County in their internal audit department for over 13 years as a professional auditor. I also spent some time at the Maricopa County Community College Districts as an internal auditor.
Thank you. So I just want to briefly have you go over election day voting in Maricopa County. So as an initial matter, what are vote centers?
So a vote center in Maricopa County has used these since the 2020 cycle is it's different than the precinct-based voting model, is where it allows a voter to vote at any one of our voting locations. So in 2022, Maricopa County offered 223 vote centers for the general election. That was an increase of over 13 vote centers from the 2022 August primary, as well as was an increase from the 2020 general election, which saw at 175 vote centers.
Okay, thanks. So if you could just walk me through when a person comes to a vote center, the process for them to cast their ballot.
Yeah, so first, they will arrive at a voting location. We have what we call a site book, but that's in state statutes, that's referenced as an e-poll book. It's essentially our check-in station. So that's going to allow the voter to proceed and check in themselves up until a certain point, confirming their name, their address, that type of information. And then once they get to a certain point, then it will ask that voter that they need to prove identity. So then it will stop, will not let them proceed any further. One of our poll workers will then go and check that voter's identity.
Ms. Krieger, can we move the microphone a little closer to the witness, wherever your microphone is? There's some breakup, and we'd like to get every word. A court reporter is struggling to get every word.
Just speak loudly. We can't get it any closer.
Your Honor, I'll try to speak louder. Can you hear me better?
Yeah, facing this direction, that does sound better, so please do that.
So I believe that you were talking about the check-in process.
Yes, so the check-in process. So after a voter then would show identity, then it will let them proceed through the check-in process and have their ballot printed. So in Maricopa County, we have over 12,000 different ballot styles. And so we use ballot on demand technology to be able to produce those ballot styles and get that voter their correct ballot. So then that ballot would then be printed at one of our ballot on demand printers along with a control slip that identifies that voter to the ballot style. Then that voter would be issued that ballot style. They would then go to a voting booth to be able to complete that ballot. And then they could then, on election day, they can then put that into one of our on-site precinct-based tabulators.
So when a voter puts their ballot into a precinct-based tabulator at a vote center in Maricopa County, explain sort of the scenarios that might occur when that happens.
So when they go to insert their ballot into a tabulator, it could be read by that tabulator. Now, there could be instances where a voter may overvote a contest, right? So an overvote would be if we have a contest that is a vote for one, and the voter fills in two ovals. So then it would alert that voter that that contest has been overvoted, the specific contest. And if there's multiple, it'll list all those contests, alerting them that they had overvoted the contest. If they had left a ballot completely blank, so no voted contests on the ballot were blank, it would also alert the voter that that's a completely blank contest and allow them to then return that ballot to themselves. And then at that point in time, the voter has a decision to make. Are they going to cast that ballot as a completely blank ballot, or are they going to refill in those ovals, spoil that ballot, get a new ballot issued. Another scenario would be if there's an ambiguous mark on the ballot. So an ambiguous mark is when the mark is not completed more than 35%. So sometimes that would be a check mark or an X with a very thin writing utensil. So then the precinct-based tabulator would alert the voter that there are ambiguous marks on the ballot. It does not alert the voter to which contest, because it does that. There's no opportunity for the voter to be able to resolve that. So then the only options for that voter at that point in time are to either put those ballots with those ambiguous marks into door number 3, our secure ballot drop box in Maricopa County, or to spoil that ballot, get a new ballot reissued, so then they can complete it without the use of check marks. So they're filling in that oval, so it can be inserted into the tabulator.
So in those situations on election day, when a voter is placing their ballot into the tabulator and they're alerted to one of these issues with their ballot, the voter, what's the option for the voter? What decision do they have to make at that point?
So the tabulator is alerting the voter to if there's one of those issues occurring. So then the voter has the option to return that ballot to them and to inspect it. And then it is their choice to decide how to proceed. So it's whether they want to reinsert it into the tabulator and have the tabulator accept it as is for those overvoted or completely blank contests, or for the ambiguous marks to drop into door number 3. But it's completely the voter's choice at that point in time.
So when the voter makes that decision, are they, showing, I guess, what their intent is with respect to that ballot, to vote the ballot as is or to make a change?
Yes, that's correct. That's the voter has made their decision on what the intent is for those specific situations.
And just quickly, why is it that voters have, or the recommendation from Maricopa County is for voters to use blue or black pens?
So the reason we make that specific recommendation is we don't want voters to use red ink or yellow highlighters, because on red, our tabulators are specifically programmed not to read red ink. And the reason we do that is in all of our processes, that's what we hire our temporary workers to use. So then they could not inadvertently make a mark on a ballot that then could end up causing a stray mark that would then be read by the tabulator. So we use red ink throughout the entire process. So we alert voters to use either black or blue ink. And either of those colors of inks are fine and can read just fine on our tabulation equipment.
Thank you. So I want to talk about electronic adjudication boards. Can you explain the role of an electronic adjudication board at Maricopa County?
So the role of the electronic adjudication board is actually established in the state law, so Title 16, as well as the Elections Procedures Manual. So they must be a bipartisan team or a board made up or comprised of 2 judges. They have to be from the 2 largest parties, that's a Republican and Democrat. And then there's also an inspector that is part of the board. Now, the state law does not require them to be of any particular party. Maricopa County, we only hire an inspector that is registered as an independent or a libertarian to keep that fairness of the bipartisan team. So their role is to review ballots that need to go that a tabulator cannot determine the intent. So a lot of times those are those overvotes. So every single overvote that's registered on a ballot that comes through central count. So those early ballots will go to an adjudication board. Again, a completely blank ballot would also go to an adjudication board. But one of the more common, and especially for the 2022 election, that went to an adjudication board was write-ins. So none of our tabulation equipment can read handwriting. So if there is a vote for a write-in, and then there's a write-in contest, in a contest that has a qualified write-in, that would go to an electronic adjudication board to review, determine, was that a vote for a qualified write-in or a non-qualified write-in?
And how many members are there on an adjudication board?
So there's a total of 3. There's 2 judges and then the inspector.
And what's the criteria for the makeup of an adjudication board?
So it has to be a Republican and Democrat of both different parties. For this past election, we had 22 adjudication boards working at a single point in time, but we did run 2 shifts, so we had hired just over 90 adjudication boards. We would transition those same adjudication boards to another process that we call duplication. And they perform both of those functions within our central count facility. And all of this, we call that our ballot tabulation center, or the BTC. All of that is under observation from, well, under 24/7 live streaming cameras, as well as every time that we're performing any adjudication action, duplication action, or tabulation, the political party observers were present observing as well.
And do the members of the adjudication board receive training?
Yes, we provide them training on test ballots and test decks. So we have a famous names ballot, though, that will be 2 different sides. And we go through all the different scenarios that a adjudication board may receive. And a lot of those are come through the Secretary of State's voter intent guidelines. It comes through our training, and then prior scenarios that we've encountered where boards have questions about how the adjudication process happens. So that's a full day of training that we provide to them before they begin the electronic adjudication process. I do want to point out too, as they go through and perform the electronic adjudication process, they are creating a handwritten log of every action that they are taking. And that at the end of every shift, we print out a system generated log of every action that they took. At the end of that shift, so before their lunch shift, before their afternoon shift, they're reviewing those logs, comparing those logs, and making sure that they match before we would then transmit or process any of those ballots to be moved into the results tallying and reporting system.
So, and I apologize, Your Honor, I'd like to talk about some exhibits. It was marked as Defendant's Exhibit 8, which is the electronic adjudication board procedure, but I'm not sure. Do we know which number that is now?
Is it Defendant Mays or Defendant Hobbs exhibit? It's only one defendant exhibit.
Exhibit 16. Okay, I believe it's Exhibit 16 now.
Oh, wait. Exhibit 8 is the adjudication quick reference guide, and Exhibit 9 is the adjudication board procedures.
It's okay. Let's start with the electronic adjudication board procedures,
Okay, which is Exhibit 16.
It's Exhibit 16. My apologies, Your Honor.
You want me to
All
share?
right, can you share that with everybody, or can we share it with everybody? Is that, go ahead.
Ms. Hartman Tellis is going to share her screen for this.
Say it again. These are not sealed, no.
Thank you. All right. Scott, do you recognize this document?
Yes, I do. It's our procedures that we've developed in-house here in Maricopa County to guide electronic adjudication boards through the process and the role that they play in performing electronic adjudication.
And, well, actually, Your Honor, I'd like to move this into evidence, please.
Any objection, Mr. Lasota?
No, Your Honor.
Order admitting Exhibit 16 into evidence.
Thank you. And I'd like to move on then to Exhibit 17. 15?
What's the title?
I'm sorry, Adjudication Quick Reference Guide.
It is 15.
Okay, Exhibit 15.
All right, we have that on the screen now.
Thank you. Scott, do you recognize this document?
Yes, I do. This is a document that was produced through the, by Maricopa County to align with the Secretary of State's voter intent guidelines. So, and it provides lots of different scenarios of what an adjudication board might see as they're making voter intent determinations.
And I'd like to go over this one in a little bit more detail. So Scott, if you could just explain sort of these scenarios that are here. So the first one is the vote for one or vote for two scenario. What is this telling the workers?
So the vote for one is, so it's set here, we're describing situations where they're not going to take an action. So that's why there's that little circle with the cross through it. So it's learning to the voter or the electronic adjudication board. They leave these as they are within the system. So there's no need for them to take an action. So here we see for that vote for one, clerk in the recorder, there's a oval completed for Deborah A. Johnson. So that would then mean that that is being registered. So we have a green highlight there. So when the electronic adjudication boards are performing their role, the system provides an overlay to inform the board of how the system's interpreting the mark, right? So here there's a green mark. It's overlaying on that oval saying this is being counted as a vote. It's a vote for one, so there's no action the electronic adjudication board needs to take. Same for the vote for two. Here's a contest that has more than two candidates on the ballot, but the voter can make two choices or two selections. So there's two ovals filled in, again, so there's no need for the adjudication board to make an action.
Okay. And then let's move over to the overvote scenario. What is that explaining to the adjudication board?
So here,
Your Honor, I'm going to object on relevance grounds. I think we're getting far afield, and I think it's your job to decipher voter intent ultimately. I think the training that was received I think we'd all agree there's significant training that goes on, but I think the question is, did they get it right? And I don't think this is relevant to that.
Your Honor, may I respond?
Sure, Ms. Geiger, go ahead.
Well, my understanding of the position is that had these votes been adjudicated, they would have been determined differently. And I think the training that is received and the way that adjudication boards are trained across the state so that there's consistency is relevant to the analysis of how these ballots would have been adjudicated with an adjudication board.
Yeah, and I understand that. Mr. Lasota, do you object to the admission of these exhibits as they relate to what I have to refer to?
Your Honor, I don't object to a small number of exhibits just for background purposes, but I think it's up to you to decide voter intent on the ballots we've offered, and whatever one's training was. I think if you believe they got it wrong, the fact that they were well trained is not relevant.
Your Honor, just briefly, Mr. Lasota is accusing these election workers of misconduct. Okay, this is certainly relevant to whether they engaged in misconduct.
Your Honor, we're accusing them of simply not counting the ballot the right way. I mean, if you want to call that an accusation, go ahead.
Well, I guess then you should be dismissing your misconduct claim, shouldn't you?
Mr. Barr, arguing doesn't help anything.
Just trying to speed it along, Your Honor. I'm sorry.
All right. The objection is whether or not we're going to spend the next however long going through this document in detail. I guess, Ms. Krieger, I would ask you to speed it along. I do get that there's been training, and if you could just talk about that, what your election officials go through without, we don't have to go into detail about what this quick reference guide means, in my opinion. So I guess I'm partially sustaining the objection and partially overruling it. I think you have a right to present evidence that your people that did this do get training, and I think that is being done through the admission of these documents. And any anything else you want to tell me about what process the trainers go through, but some of the details are not as crucial. So go ahead.
Well, thank you, Your Honor. I do want to go over, although we have not heard from the plaintiff as to what their position is on any specific ballot or what the basis for their belief that it should have been tabulated differently, I'm trying to address, their perhaps misinformation based on the fact that they haven't been trained on how to do adjudication. So I'm guessing right now on what their basis is.
Well, you only have 6 ballots to look at, and they're pretty easy to guess on from my perspective of what their argument is on those 6 ballots. So let's move along. As you know, again, we're going to be way ahead of what I thought, but I just don't think we need to get firmly entrenched in going over every training session that everybody went through. But you've seen those 6 ballots, and there's check marks on 3 of them and an X on 1 of them, and whether or not they're trained to record those is an issue, I guess. So.
Okay. Thank you, Your Honor.
Go ahead.
Okay. So when there is an ambiguous mark on a ballot, what is the training and how do boards look at that question?
So they look to determine, and can they together determine whether they can determine a voter's intent. So sometimes it may be clear because and they're consistently filling in every single oval or on the ballot the same way. So if that's the case, then those boards can then make that voter intent. Other times they're inconsistently maybe marking a ballot. So then their training is if the ballot's being marked inconsistently throughout, then it's much more difficult than to truly make determine the intent of the voter. So then, but it is that board's assignment. We provide them training, but those boards take an oath in office. They make the determinations of if they can determine voter intent. If there's they don't agree between the 2 judges, then that's when the inspector comes in, and then sometimes they will break the tie. Usually that's very, very, very rare when those types of things have to occur.
Your Honor, I'd like to move Exhibit 15 into evidence, please.
Any objection to 15, Mr. Lasota?
No objection, Your Honor.
It is ordered
Other than
admitting
as previously
15.
stated. Yeah.
It is ordered admitting Exhibit 15. Next, Ms. Kiger, go ahead.
Thank you, Your Honor. I believe there was one additional exhibit added by the Secretary of State's office, which was the Secretary of State's voter intent guide. I'll get you an exhibit number in a moment.
Let me see what that is.
It's C1.
Yes.
That's exhibit C1.
All right, go ahead.
Scott, do you recognize this document?
Yes, I do.
And what is it?
So this is guidelines that the Secretary of State issued to all counties if they were going to be implementing electronic adjudication. So when the Secretary of State was first initially drafting this document, they sent drafts to all the counties for input because we have lots of expertise in performing adjudication, whether that was electronically or when we were duplicating a ballot. Maricopa County was one of the first counties to adopt electronic adjudication. So we had we played a role, and my team played a role in providing feedback to the Secretary of State on ways that they could improve the document that would serve voters and our electronic adjudication board as well.
And is Maricopa County's training and processes with respect to adjudication consistent with what's contained in this guide?
Yes, they are. Our guidance that we issue as well as the training. We follow this to have consistency throughout the entire state.
Okay, thank you. Your Honor, I'd like to move Exhibit C1 into evidence, please.
Any objection to C1?
No, Your Honor.
All right, it is ordered admitting Exhibit C1 into evidence.
Thank you, Your Honor. So, Scott, are you aware that a ballot inspection took place here at McTech yesterday?
Yes, and that's the Maricopa County Tabulation and Election Center, our acronym McTech, yes.
And were you present for that inspection?
I was present partially. I was in court providing testimony in another case for the morning, but in the afternoon and the evening, I was here observing that inspection.
And are you aware that some of the parties involved in that inspection flagged certain ballots?
Yes, I am aware of that.
And have you looked at all of those ballots?
Yes, yesterday evening after the parties left, and we actually made it clear that I would be going through and reviewing each of the 14 ballots that they had wanted to be submitted as exhibits.
And there are, I believe, 6, is it, that have been, or 7 flagged by Mr. Hamadeh. Is that your understanding?
My understanding was 6.
6, maybe you're right. Sorry about
6
that.
ballots that were flagged by the plaintiffs, and then the defendants had flagged 8 ballots.
And did you review those 6 that have been flagged by the plaintiff in this case?
Yes, I have.
And what was your analysis with respect to those ballots?
So based off the procedures that Maricopa County has identified, that those should not have been sent to an adjudication board to be adjudicated, only to be sent to an adjudication board to be reviewed for write-ins. Because they are election day ballots, well, sorry, not all of the 6, I believe 4 of the 6, that was the situation. There was 2 that ballots that went to a adjudication board to be reviewed because those were door ballots that were inserted into that door number 3, our secure ballot box, and brought back to the elections department. Because those ballots were inserted into that door number 3, that voter did not have the opportunity to review that ballot getting and notified by the precinct-based tabulator that there may be a voter intent issue. So in those 2 instances, those ballots were then sent to a electronic adjudication board to be reviewed for voter intent.
And so with respect to those 6 ballots, did you believe that they were tabulated correctly?
Based off the process that when we don't send a ballot that is from election day and a voter had an opportunity to tell us their intent and not sending those to an adjudication board, yes.
And well, I think that, can we take just a brief break, Your Honor, quickly?
How long, Mr. Margaret?
I think, Your Honor, that Ms. Duell has some questions for Mr. Jarrett as well.
So are you done asking questions? I don't want to, I don't mind Ms. Duell taking over and asking questions, but I just want to.
I'm finished, Your Honor. Thank you.
All right, Ms. Duell, go ahead.
Your Honor, this is Mr. Gaona actually speaking. I just wanted to clarify one thing that Mr. Jarrett was talking about there, and I'm not sure that this was clear from the record, which is, Mr. Jarrett, you reviewed all, I believe you said it was 14 ballots that were flagged by either side in this case for further review and that are now in evidence before the court. Is that correct?
That's correct.
And based on your review of those 14 ballots, what is your position about the swing one way or another in terms of how those ballots should or should not have been adjudicated? And I'm asking that question in the sense of how the count would actually change based on those 14 ballots now that you've looked at them again.
So based off the total of the 14 ballots, based on the procedures that Maricopa County has set forth, that's as I understand your question, I determined that there were 3 errors on those ballots that should have been adjudicated differently. And those 3 errors all were in the favor of the candidate Mays.
Okay.
Or would have added 3 more votes to the candidate Mays.
Okay, thank you. No further questions for this witness, Your Honor.
All right, so that was Ms. Duell's question. All right, so Mr. Lasota, any cross of the witness?
Yes, Your Honor. Thank you, Your Honor. So, Mr. Jarrett, let's start with the 3 errors. Which, and I don't think we have exhibit numbers for the for the ones offered by the other parties, but let's start with the last 6 digits. Which ones do you think were erroneous? And can you go through one by one what the original count was and what you think the count should have been?
Yes, I can. So the first was a 700906 underscore 03. So 70009 underscore 06 003. And this was a, am I able to look at that ballot?
It's Exhibit 13. You can't put it on the screen, but
Exhibit 13.
yes.
Yeah, I believe it's Exhibit 13. If that's 70009 underscore 6 underscore 03. Yes.
Yeah, it is Exhibit 13 on our case lines. It has been admitted.
So in this document, you can see that there is a consistent voting pattern for the ovals. Here there are check marks or dashes that are being filled in. So, and in this instance, this was on, if you scroll, Your Honor, through the document to the next pages, you can see how this was read by, zoom in. With every ballot is affixed with an audit mark. It says how it was read by the tabulator. And then there's a new audit mark that's affixed that as it was adjudicated by the electronic adjudication board. And in this situation, the ballot was not adjudicated to award a vote for the candidate Mays. So this is an election day ballot that was actually inserted into that door number 3 that went before adjudication board. Those adjudication boards were supposed to be making a voter intent determination. They made an awarded contest on this ballot for some of the candidates that had those check marks. In this instance, they left it as a undervoted contest, not a voted contest. So they did not.
Attorney General.
Mark.
Yeah, I've got that.
For the Attorney General race. Is that?
That's correct, for the Attorney General's contest.
Okay. So that went from an undervote to a vote for Mays in your mind?
If I was a member of that 3-party adjudication board, that's what I would.
Well, that's not, see, I'm talking about voter intent because that's what the statute says, right? That's what case law says is we try to glean the voter intent. So my question is so you think the voter intent there was in favor of that the voter cast a vote for Mays, correct?
Yes,
Okay.
Council. As I go through and look at all the different ovals, to me, that's matching. The mark in that is similar enough to all the other ovals that would be a vote for Mays.
Okay, thank you. And if you could just go through the next 2. And my question goes to voter intent. It doesn't go to any of these adjudication boards. So just tell me how it was counted originally and how you think it should be counted.
I understand. Okay, so then the next 2 ballots, so the number is 3011 underscore 116 underscore 149.
That's Exhibit 4.
Exhibit 4. Yes, that's correct. So in this situation, this is an early ballot. So all early ballots go to an electronic adjudication board. So when I look at the Attorney General's contest, there is currently this is showing as an overvote in this contest, right? There's a oval, so filled in for Mays, and then there's an oval filled in on the write-in line, and also then the candidate's name, Mays, that first initial, K, is completed. So as guidance issued by the Arizona Secretary of State, their voter intent guidelines, in these situations, we train our electronic adjudication boards to remove the overvote. So to remove that mark that is causing this to be an overvote. And in this situation, the adjudication boards actually adjudicated this to be a vote for a write-in candidate, non-qualified, and then that resulted in this being an overvote, not a vote for Mays.
Okay, thank you. If you could go to the next one, that'd be good.
So it's 03001 _ 183 _ 37. That's exhibit 5.
Correct.
So in this situation, this is somewhat similar to the last one, but there's two ovals that we're looking at. The first oval is a vote for Chris Mays. The second oval is what is a partial oval being completed. So here, this looks as if there was a pen rest. So someone rested their pen on that oval, then went in and filled in that vote for Chris Mays. This would then, in my opinion, we would need to remove the overvote. So this could be then a vote for Chris Mays. And the adjudication board actually left it as an overvoted contest.
Okay. Well, let's move to the ones that and you have all these ballots, correct?
Yes, we'll pull them up. If you can give us the exhibit.
Sure.
Yeah, the exhibit number.
Yes. So let's go ahead and start with exhibit number 6, which is the one ending in 84.
Exhibits. Okay, yes, I see this.
And this was counted as an undervote, correct?
That's correct.
And it's your position that you cannot glean the voter intent from this ballot on the Attorney General's race?
So my position is this was one of the ballots that was read in, or the voter had the opportunity to tell us their voter intent at the voting location. So here, this is a completely blank ballot. So every contest on this ballot, there's no marking going into any one of those ovals. So this would have alerted the voter that this is a completely blank ballot. And since we don't send these ballots to election day ballots to adjudication because the voters have informed us of their intent, I would not then be able to overrule the voters' intent.
Okay, so it's your position that the voter intended to cast a completely blank ballot in this case?
It's my position that because it's an election day ballot, that the voter had the opportunity to tell us their intent, and they accept.
Well, maybe they said, "I just cast my ballot. What do I have to tell you my intent for?" Isn't that a possibility?
So we have the tabulator alerts them to every contest that's undervoted. We also have signage, which was passed in the last legislative session, that we have to put that on all of our precinct-based tabulators or near our precinct-based tabulators, describing these situations and alerting the voter to that it's their determination of what an overvote or undervoted contest.
But if the ballot goes to door 3, which the county confidently told everyone that if the scanner, if your ballot can't be tabulated, just put it in door 3, correct?
That's correct, but this ballot didn't go to door 3.
Okay, but if it had, there would have been no opportunity to make to submit another ballot, correct?
If it went to door 3, that's correct. We sent those door 3 ballots to adjudication, to a bipartisan adjudication board.
All right, and it's your testimony that looking at this ballot, that you do not think the voter intended to vote for Mr. Hamadeh.
I think that's a slight mischaracterization of what I said. It's that the voter had the opportunity to make a correction on this ballot if they had wanted to.
But how do you know what was told to the voter? Were you there?
I know that the tabulator would have informed the voter that they're programmed to do that based off of if it was a completely blank ballot, which this is, and that the signage on those ballot boxes also informed the voter.
Okay, but you don't know, you have no direct knowledge that the voter was told any of that verbally, correct?
That's correct.
And you don't know if the voter happened to see this sign, correct?
I don't know that they saw the sign. I know that the tabulator would have read and provided that information to the voter.
But for all you know, the poll worker said, oh, just don't worry about it. They'll figure it out.
Objection, Your Honor. This calls for speculation.
Oh, that's overruled. He can answer the question if he knows, or if he doesn't know.
I don't have any knowledge to that.
But so that's possible, correct?
It's possible.
Okay. All right. Well, let's move on to Exhibit 7. And so here we have a. Do you have Exhibit 7? It ends in 410.
Yes.
Okay. And this ballot was officially counted as an undervote in the Attorney General's race, correct?
That's correct.
Okay. And it's your testimony today that that your analysis of voter intent is that you cannot tell who this voter intended to vote for in the Attorney General's race.
That would not be my testimony for this ballot.
Okay. Well, tell us why you don't think it should be counted as a vote for Mr. Hamadeh.
So in this specific situation, this ballot came back to the elections department in the black canvas bags. When we did our audit reconciliation of those bags, we found a variance between the number of check-ins and the number of ballots that were tabulated at that voting location. When we did that, we opened up the black canvas bags, we performed our audit reconciliation, and if we identified that there was a difference between the number of ballots that were read in on election night from the memory cards and the number of ballots that were in the black canvas bags, then we used our central count tabulator to run those ballots from the black canvas bags and accept those into results. Since those were coming from the voting location, we did not send any of those to our electronic adjudication boards to review in that specific situation. So my testimony will be that this ballot did not go to an electronic adjudication board to be reviewed. It was only to be reviewed for a write-in contest.
Okay. Well, I think my question is, who do you think this voter intended to vote for Attorney General, if anyone?
Yeah. So based on that question, I can make a determination. It would be for there's a clear and consistent pattern for Hamadeh.
Okay. So you think that this was improperly counted as an undervote, correct?
Objection. Misstates.
Asking the question, overruled.
Yeah, I would not state that.
Okay. Well, what would you state?
I would state that this went to an electronic adjudication board just to be reviewed for voter intent, or for a write-in candidate.
Okay, so I'm trying to move the questions along. I don't care about the adjudication boards for now. I mean, I know they're important, but I'm asking about voter intent. So is it your tests and okay, so just to review, this was counted as an undervote, correct?
That's correct.
All right. But I think you just testified that this voter, if you had to look at it, you'd say they intended to vote for Mr. Hamadeh, correct?
Yes, that's correct.
So how is that not whatever we want to call it, how is that not a miscount? And I'm not saying anyone even did anything intentionally wrong, but how could you say that this is a properly counted ballot?
Based on the procedures that we set forth, that's why I'm saying that the adjudication board made the correct action. But I concede that I can see the voter intent there.
For Mr. Hamadeh?
Yes.
Okay. Okay, let's go on to Exhibit 8, which ends in 054. And let's kind of just go through the same exercise. And would you agree this one looks like a lot like the one that we reviewed that you said should have been counted as a vote for Ms. Mays, correct?
I agree that when I look at that oval and the consistency of that oval, how other ovals are filled in by this voter, that looks like an intent for Hamadeh.
Okay. But this was in fact counted as an undervote, correct?
That's correct.
Okay. And in terms of exhibit, I've got my exhibits written down on my phone and keeps going blank, so I'm sorry for the gap. The next one is Exhibit 9, 000711. Are you there?
Yes.
And this looks like the last one. This was counted as an undervote, correct?
That's correct.
But would you agree that it evinces an obvious intent to cast a vote for Mr. Hamadeh?
Based off the consistent marking pattern for those ovals, yes, that
okay.
I can determine intent.
Okay.
And voter intent, that's a vote for Hamadeh.
Okay, based on voter intent. Okay. All right. So we got the two 142s. So let's go to exhibit. Let's go to exhibit number 11, if you will, and that's the one. It starts out 07009. And just tell me when you're there.
There are several there's more than one that start with that.
The 07009 is exhibit 14, Mr. Lasota.
Yeah.
Oh, that's right. I'm sorry. I'm looking at 07008 and also that ends in 142. And there's a bunch of zeros in between.
That's exhibit 11.
Exhibit 11, correct. And just, Mr. Jarrett, just tell me when you're there.
I see that ballot.
Okay. So this voter, it looks like in some cases they like to mark the Republican and in other cases they like to mark the oval. Is that correct?
That's what this voter is doing. Yes.
Okay. So in terms of marking Republican for the candidate, would you say maybe it's not as distinct as the pattern where they do everything else for the candidate, like they do a check mark instead of filling it in? But would you say there is a pattern of sometimes they just like to scribble over the Republican?
There is a pattern of scribbling over the Republican.
Okay.
Yes.
So what is if you had to glean voter intent on this, what would your position be?
So this is an inconsistent marking pattern, right? Sometimes they're filling in the oval or attempting to fill in the oval, and sometimes they're, so I could not make a confident determination that I know voters' intent.
Okay. But you can see on, so he marks the Republican for Kevin Thompson, Kimberly Yee, Abe Hamadeh, and David Livingston. Is that correct?
See, would you repeat the names again?
Yeah, Kevin Thompson down at the Corpcom race. Looks like maybe he was running out of a little energy here. Actually, if you go all the way down to Rachel Mitchell, he seems to scribble there. So we got Rachel Mitchell, Kevin Thompson, Kimberly Yee, Abe Hamadeh, and David Livingston, where we've got nothing in any oval, but we've got Republican scribbled out with pen.
Yes, I see that. Yes.
Okay. All right. Well, let's go on to the last 142, which by process of elimination, hopefully everybody can get there, is Exhibit 14. And I assume your testimony would be the same, that this is the voter intent cannot be gleaned here?
That's correct.
Okay.
It's an inconsistent voting pattern.
Right, but there is a mark next to Mr. Hamadeh's name, correct?
Yeah, every other oval completed.
Well, that's not like you could answer that, but okay. And I would, it is true that, yeah, well, I haven't looked at the whole thing, but most of the time this person does do the oval. So, okay. That's it for our exhibits. I'd like to ask some questions on so the provisional ballot list. Would you just kind of briefly explain that?
Objection, Your Honor, that's outside the scope of direct.
You can answer.
Can you, I'm not familiar with what exactly you're describing.
Yeah, you're right. That was a poor question. So in terms of, so you got provisional ballots and basically they are ballots that as of election day, they may or may not be counted, correct?
That's correct.
Okay. And for example, on some of them, the parties work to, get the voter, maybe if there's a voter ID issue, they get the voter to call the county and get that straightened out so their ballot counts, correct?
That would be a conditional provisional, yes.
Okay. Now, in terms of and then others, can you tell us another reason why a provisional ballot that's initially provisional would count?
So in some instances, we may and this is under the purview of the Maricopa County Recorder's Office. So they do the research on the provisional ballots, but in some determinations, every single provisional ballot will come back to the Maricopa County Elections Department. Those get transferred to the Maricopa County Recorder. They do various types of research to make sure whether it should stay in a provisional status and be counted, accepted, or rejected so some of the reasons why they would be accepted would be because maybe when they did their analysis and they looked at the actual paperwork, maybe it was a hard copy registration form that we received before election day, but was entered in incorrectly, like the date was. They'd do that research, they'd identify, this was a voter that actually was registered to vote by the timeline. So that'd be one reason. Other reasons why we would accept is if we made determinations that a voter voted at one location and went to a second location, and we could gather enough information to determine that they didn't vote and actually have their ballot tabulated at that first location, then we could count that provisional ballot as well.
Okay. Now, and whether it's conditional, provisional, that's information that is promptly given to the parties and other third parties that ask for it, correct?
So, Mr. Losada, I don't know specifically if that information is given to them. Similar to like the early ballot information, if they have a questionable signature, that question would need to go to the Maricopa County Recorder's office.
Well, okay. Well, you saw the article. Well, did you see the article about how Ms. Mays had a lot of success in rehabilitating the conditional provisional ballots? It was in the Arizona Republic.
I did not see that article.
Okay. Well, can you think of any reason why these lists of provisional ballots would not have been turned over to Mr. Hamadeh pursuant to a public records request?
Objection, Your Honor.
Objection,
He
Your-
already testified that this is outside the scope of his job duties. And this is under the recorder. And we can explain that this is outside the scope of direct, but we could explain the division of the departments between the recorder and the Board of Supervisors and what is under Mr. Jarrett's responsibility, if that would assist the court.
No, you could have just answered the question saying that it's not part of his responsibility, and we could have moved to the next question, and maybe we'll get the recorder later, but it is overruling the objection. You have a right to explain to me what the division is, and I hope to hear that, but this is a question he was asking Mr. Jarrett.
And I can rephrase, Your Honor, and I know you overruled the objection, but maybe are you competent to, that is, do you have knowledge to testify as to this question?
I do not know. Well, can you repeat
Sure.
the first question?
Yes. Well, and let me start here. I mean, obviously, Mr. Richer has his responsibilities and you have yours, but I think it's probably fair to say you have significant knowledge of Mr. Richer's responsibilities, even though they are his responsibilities. Is that a fair statement?
In some areas, that's correct, yes.
Okay. So can you think of a reason why these lists of provisional ballots would not have been turned over to Mr. Hamadeh?
I have no knowledge. I don't know if Mr. Hamadeh made a request. I don't know if they were provided or not. I have no knowledge of that.
But they're clearly a public record, correct?
Objection, Your Honor. No foundation.
Lay some foundation whether he would know.
Okay. Well, you obviously know that there are provisional in every race. There are provisional ballots, conditional provisional ballots. I think we've established that, correct?
That's correct. Our every election, yes.
Okay. Now, and obviously voter and lists are kept of who has voted and who has not voted and who has voted conditional or provisionally, correct?
Yes, that's correct.
Okay, and that list, in your mind, would such lists be a public record?
Objection calls for a legal conclusion.
Your Honor, and I'll add, I mean, what is this line of questioning relevant to anything pled in the complaint?
The objections are overruled. Just if he can't answer the question, we'll just move on to the next witness that will. But I just let's just let him answer the questions if he can. So
just for the record, Your Honor, I mean, how Maricopa County responds to a public records, request in no way implicates any issue raised in the complaint.
All right, thank you, Mr. Barr. Your objection is noted, and it'll be part of the record. Just answer the question if you can.
Can you repeat the question, Mr. Lasota?
So a list of who's voted, who hasn't voted, who's voted provisionally, kept by the county, that would be a public record, correct?
That would be our voted file. That voted file is not produced until after the canvass. And we do have a complete list of that and the people can make, so that information is provided to the different townships, the political parties through their file, but that information can also then be submitted through a data request. And then based on the number of voter files that are included in that, there's a charge related to that.
Okay, but it would be.
That's my knowledge.
Okay.
That's produced after the canvas.
Okay. Thank you, Mr. Jarrett. Now in just so that in terms of the undervotes like an undervote typically does not go to adjudication. Is that correct?
That's correct. Only in the case of a completely blank ballot.
Or if maybe some other, because we did see some that went to adjudication. So if there's maybe a stray mark, maybe it picks it up and flags it. Is that accurate?
That's correct. An ambiguous mark may go, and then if the board can't determine intent, then they would adjudicate that as an undervote.
But if the tabulators I know it's a machine, but if the tabulator's conclusion is there is no mark for any candidate, then that doesn't go anywhere further. It just gets counted as no vote for either candidate in that race, correct?
Yeah, unless there's two situations where that might not happen. One, again, would be a completely blank ballot. And then the second would be, and you were just describing it in your prior question, is if that ballot went to an adjudication board for another reason, right? And then if that was presented to the adjudication board for another reason, and then those boards were reviewing it and they saw a mark there, then they could, and they agreed as a board, they could determine voter intent for that contest, and they could adjudicate that to a vote.
Okay. If I could have a moment, Your Honor, just to look at my notes.
Go ahead.
Mr. Jarrett, just in terms of the, if an undervote is reported by the machine and the voter is given a chance to correct that, I mean, is the word to the voter that there is an undervote, or does it tell them what was undervoted?
Yeah, so the tabulator itself will list all the contests. If it's a completely blank ballot, it will list all the contests that it was a blank ballot and those were undervoted. If it's a single undervoted contest, yes, it will not alert the voter that there was a single undervoted contest.
Okay, so it'll just say undervote, and for all they know, it could have been in a judicial race, correct?
No, it would be for a completely blank ballot. It would alert them. So, right. So only does a voter get notified, and this is voters that are on election day when we had an on-site tabulator. It will alert them that they've undervoted that entire ballot.
Okay, so yeah. I'm
but
sorry.
If it was
Go ahead.
A few ovals were completed, even one oval was completed on that ballot, and every other contest was not completed, it would not alert the voter that they, and that's common. Voters very frequently only vote for one or two contests on the ballot.
Right. Okay. I don't think I have anything else, Your Honor. Thank you.
All right, thank you.
Your Honor, I have some brief redirect for Mr. Jarrett. If you want to do that now, and I think what I would suggest after that for the court is a break, so those on this side of the V can determine whether we have any further witnesses to present or whether we can come back and do closings, if that would work for the court schedule.
That works for me. Go ahead, Mr. Gayona.
All right, thank you. Mr. Jarrett, Mr. Lasota just went through all of the ballots that his inspector had identified as potentially being ballots that should have counted for Mr. Hamadeh. Do you recall going through all those ballots with him?
Yes, I do.
And I'm sorry, my video's not on. There we go. And you also recall going through some of the other ballots that you had testified earlier to that you believe should have counted for Ms. Mays. Is that correct?
That's correct.
And having looked at the ballots last night, after they were flagged by the parties, and having looked at them, again today, I just want to get to summarize everything we just went through for the court. I just want to clarify that your belief, based on your experience and your training, remains that of the 14 ballots that were isolated by the parties, that your conclusion is still that the net from those 14 ballots is that 3 of them should have counted for Ms. Mays. Am I correct in that?
I'd add, based on my knowledge of the procedures that we established for Maricopa County, and which types of ballots would go to adjudication or not, yes, based off those other items, I believe that there would have been a net gain of 3 votes for Mays.
Okay, thank you. No further questions, Your Honor.
All right, does anybody else have any questions? Mr. Krieger?
Sorry.
Mr.
Your
Moore?
Honor.
I have no questions, Your Honor.
All right, so I guess I kind of like to figure out if we're just going to go to closings, that's going to take a little while to do. I would like to maybe start that at 1, if that's what we're going to do. That gives you some time to prepare. But if we're going to have another witness, I would like to do that. Start that witness this morning. So we're going to take a 10-minute break, and you're going to let me know by 11:25 whether or not we're going to have another witness this morning and get as much done before we go to break, or we're going to come back at 1 for oral arguments. So if you guys can let me know that by 11, let's give you it 11:30. But
I was going to say,
yes.
My apologies. Can I ask Mr. Jarrett one more question just about how many ballots were reviewed total yesterday?
Your Honor, Mr. Lasota has opportunity. Recross is not allowed in Arizona.
Yeah, I would like to know that question. I've already heard it answered by Ms. Grande, but certainly, Mr. Jarrett, let me ask it as my own question. How many ballots did the Maricopa County review yesterday?
So I don't have the specific numbers right in front of me. I know there was, I think, 2,300 that were undervoted ballots. There was just over 100 undervoted ballots that were reviewed. And that was out of 50,000 that were being reviewed. And then there was just over 106 ballots that went through adjudication that were reviewed.
All right, that's consistent, maybe a little lower than what Ms. Grande testified to, but that's consistent with the general idea. So any follow-up to that, Mr. Gaona?
No, Your Honor. I was just going to flag one logistical issue in terms of coming back. If we don't have any witnesses and we come back at 11:30, I presume that 10 minutes for the active defendants in each of this, if that would be enough for closings, and we could wrap this up presumably by noon, if all the parties would agree, assuming we don't call any witnesses, so that we're not having to come back after 1, if that would be okay with the court.
Yeah, that'd be miraculous almost. Yeah, let's do that. I certainly don't have any objection to that. I thought you might want to argue longer, but
I mean, I can just speak for myself, Your Honor. I probably have, 3 or 4 minutes personally. I don't know can't speak for Mr. Barr, or if the county wants to give a closing, or what Mr. Lasota plans, but I would think that between all of us, we could get it done in 30 to 40 minutes at most.
You agree with it, Mr. Lasota?
Yes, Your Honor. I don't need a lot of time myself. Thank you.
I have some experience with Mr. Barr that may
Your Honor, miracles are our business. We'll get it done.
All right. Mr. LaRue, you agree with that?
Your Honor, in general, yes, I agree with that, but I have something I'd like to offer to the court if it would be helpful.
Sure.
We could put Mr. Jarrett back on briefly at 11:30 if Your Honor would like. And by that, he could get the information regarding how many ballots were examined yesterday and in what categories. And that might be helpful for the court, for him just to provide that information to the court.
I thought he answered it well, and it was close to what Ms. Grandy said. I don't need any additional information.
Thank you, Your Honor.
So we're going to come back at 11:30 with a witness and or closing arguments, and we'll go from there. And I'll apologize to the court reporter if you guys go way longer than your miracle promise, but we'll come back at 11:30. We'll stand at recess.
Thank you, Your Honor.
Thank you, Your Honor.
No, this part's that guy. I hope I understand better the second time.
All right, we're back on the record in CV 2022-1468, show the presence of parties in council. Mr. Gaona, are there going to be any additional witnesses?
No, Your Honor, defendants have no further witnesses, and we are ready to proceed to closings.
Mr. Lasota, you agree with that? You have the right to rebuttal, obviously.
Yes, Your Honor. No, I'm ready to proceed with closings.
All right, so you'll get to go first and last. Get started. Go ahead, Mr. Lasota.
Okay, thank you, Your Honor. In terms of some of the arguments we've heard from Mr. Barr and Mr. Gaona, I think they continue to argue the motion to dismiss that they failed on. And, you know, this business about there being no facts, no evidence, no nothing, it is just a bunch of baloney. And I just wanted to set that straight. I think we started out with 5 counts. We obviously had the 1 dismissed. We were able to do the ballot inspection and I think show a trend in favor of Mr. Hamadeh. Now, obviously, we asked for more ballots. The sample that was inspected, we didn't think was big enough, but I would concede that it was not on the order of 50 ballots or so like we saw in the Lake case. So it was we think about 2,300, 2,400 ballots. We would ask Your Honor to, and we think this is certainly within your powers under mandamus, and certainly under the right to suffrage that all Arizonans have under the Arizona Constitution. We think you should adjust the vote total accordingly. Now, in terms of what was offered for Ms. Mays, it looked like there should be an adjustment in her favor also. I don't know if it was 1, 2, or 3, but I definitely, it looked like there was at least 1, and I don't remember the exact number, but it looked like there was a vote for Ms. Mays that was not counted that should be counted. And I would submit that in this relatively small sample size, we found 6 votes for Mr. Hamadeh. I know there's a dispute as to, that it's outside of the Oval and it's on the Republican. I mean, I think that if you look at those ballots, I don't think there's any real argument who the voter intended to vote for. I think we've seen some strained technical explanations as to why those votes shouldn't count. I know Mr. Gaona asked Mr. Jarrett at the end, it's still your conclusion that it should be 3-0 for Ms. Mays. And you heard Mr. Jarrett again go back to, our procedure is we do X, Y, and Z and blah, blah, blah. Well, this procedure for this court is we try to glean the voter intent. And I mean, never mind this stuff about whether the process that they've ordained was followed. I mean, the training, I never disputed the training. And in terms of misconduct, the misconduct is just that they didn't count the votes properly. We specifically stated in our complaint we were not making any accusations of intentional misconduct or fraud. So I think just not counting a vote properly, I think goes within that very broad word misconduct, which I would concede can mean something. In some instances is sort of more of a charged allegation, but in this instance, it's just, look, they didn't count the votes properly. And I think we were clear in our complaint about that. But I think it comes back to, never mind these technical explanations. I think we did hear some, that the day of voting is treated a little bit differently than the early balloting. But I think the bottom line is, for the ballots we've been able to present, given the short time, the compressed time frame, I think they clearly show a trend in favor of Mr. Hamadeh, as we alleged in our complaint. If you extrapolate the numbers, they're not going to get us to 511 votes if you take the sample we have, and we do concede that. That's just a matter of mathematics. But every vote should be counted. Every Arizonan has the right to vote. And if it's apparent to this court of law that a vote was improperly counted as an undervote and should have been counted for any candidate based on just the court's ability to look at the ballot and say, hey, who did this person intend to vote for? That vote should be counted. I think Your Honor cut to the chase earlier with this business about, that the other side was talking about the adjudication boards and well, this person's not competent because they've not received a lengthy training session from the county or the Secretary of State. I mean, just look at the ballots. I mean, anybody can look at those, and their training is for an entirely different not entirely different. The training is meant to essentially, it is to train their workers to basically process a large amount of ballots, and to try to be consistent in that. And that's certainly a worthy pursuit, but that training doesn't mean that everything they do is perfect. And that's why we have courts of law to review that. So at the end of the day, we would ask this court to review the exhibits that have been presented in the testimony, and to make a determination as to whether the vote total should be adjusted, even though we concede we do not have 511 votes. So with that, I'll be done until I have my final rebuttal. Thank you.
Thank you, Mr. Lasota.
Thank you, Your Honor. I think I will take the lead here. Your Honor, this concession we just heard from Mr. Lasota, that he doesn't have anywhere close to the numbers to make a difference in the election, is just jaw-dropping. I mean, what have we been doing here for the past 2 weeks? I have 6 lawyers in this room who are working, the day before Christmas Eve, and untold lawyers at the Secretary of State's office and the county, and this is all for nothing. Mr. Lasota says that we're dealing in baloney. Let's talk about who's serving the baloney here. Let's go to count 1 of Mr. Lasota's complaint, where he says 126 voters voted uncounted provisional ballots. He's put in no proof of that, absolutely no proof. He next alleges 269 of these voters voted uncounted early ballots. Again, absolutely no proof of that. No even attempt to provide proof of that. No attempt to identify one election worker, what supposedly happened, nothing. Then when count 1, I mean, we heard today saying, well, we're not alleging misconduct. Well, Your Honor, counts 1 and 2 specifically allege misconduct. You can shake your head, Mr. Lasota, but that is exactly what you have alleged. And you live by the verified complaint that you filed here. So we get to that. Erroneous counts of votes. What we're left dealing with is a dispute over whether 14 undercounts in Maricopa County either produced a 3-vote margin for Chris Mays or a 6-vote margin for Mr. Hamadeh. Are you kidding me? Is that what this lawsuit is about? 2.5 million people voted in Arizona, and this lawsuit is about whether either Chris Mays got a +3 or Abe Hamadeh got a +6. I mean, I don't know what more could be sanctionable here. And let's go through the rest of the complaint. Count 2, where plaintiffs allege that 1,942 provisional votes in Maricopa County were not counted because they were unregistered voters. Well, I certainly hope so, but again, there's no proof of that. There's no discussion of that by Mr. Lasota here. And again, he alleges misconduct in count 2. There's no proof whatsoever of any misconduct by anyone. Then we get to count 3, where he says that on information and belief, there's an unspecified number of damaged ballots that were erroneously transposed, which resulted in unlawful mistabulation of the ballot. Again, there's no proof of any of that. I mean, what on earth are we doing here? I mean, people can't file complaints with no facts whatsoever and make no attempt whatsoever to prove these claims. And then finally, we get to count 4, where he alleges illegal votes. Did you hear any evidence regarding illegal votes? I mean, an illegal vote is where somebody tries to vote twice, where somebody perhaps who is a felon and can't vote tries to vote. There's absolutely no evidence of an illegal vote in this record. So what we're left with, Your Honor, is count 4. the erroneous counting of votes. And again, the only evidence in the record is our 14 ballots that were adjudicated in Maricopa County. And the dispute is whether, it's a +3 for Chris Mays or a +6 for Abe Hamadeh. Your Honor, I mean, I've been practicing law 37 years, and I've never been involved in such a gigantic waste of time as this case. And the judiciary and the bar needs to step up to the plate here and to sanction this conduct. It has gone too far for too long. And to get the admission in closing that, oh yeah, well, it really doesn't make any difference. We have nowhere close to the votes to make a difference in this election. It's just jaw-dropping. So with that, Your Honor, I urge you to enter judgment today. There is no need to waste any more time on this case and to consider our sanctions motion that will follow. Thank you very much, Your Honor.
Thank you, Mr. Barr. Mr. Gaona?
Your Honor, I believe Mr. LaRue was going to go next.
You guys have picked the order. That's fine with me. Mr. LaRue, go ahead.
Thank you, Your Honor. Earlier in this hearing, when Ms. Krager was asking Mr. Jarrett a number of questions about the county's adjudication guide, Mr. Lasota, counsel for plaintiff, objected and said something to the effect of, no one disputes that Maricopa County does a lot of training, and we appreciate that. But counsel for plaintiff also said that it is up to this court to determine voter intent on the ballots. And that's not entirely accurate. In fact, Your Honor, if that were the rule, every candidate who loses an election would file an election contest and ask the court to evaluate voter intent for every ballot. And that's not the rule. This court is obligated, rather, to decide whether Maricopa County correctly applied its procedures when it decided whether to adjudicate ballots, and also whether the adjudications that were required by its procedures were correctly done. The challenge as to whether the procedures themselves are correct, a challenge as to whether we should adjudicate more ballots or different ballots, challenges to procedures like that cannot happen in an election contest. They must happen prior to the election. And that's Allen v. State, 14 Arizona, 458. It's also Kirby v. Griffin, 48 Arizona, 434. And it's Zajac v. City of Casa Grande, 209 Arizona, 357 at paragraph 14. These decisions were recently acknowledged and followed by another division of this court. Sorry, Your Honor, it was a division of the Maricopa County Superior Court in the Fincham v. Fontes contest, which was CV 202-053927. What plaintiff really wants and what he asks this court to do is to overrule Maricopa County's procedures and decide voter intent irrespective of those procedures. But that's really a challenge to the procedures themselves, dressed up in the clothing of judicial review. And this court should not do that. Here's what I mean. Plaintiff identified a number of ballots that plaintiff believes should have been counted for Mr. Hamadeh. And plaintiff asked Mr. Jarrett, over the county's objection, whether Mr. Jarrett believed that the voter intended to vote for Mr. Hamadeh. But that's not how adjudication works, and it's not how elections work. Not every ballot is reviewed by an adjudication board in Maricopa County or anywhere in Arizona, or anywhere of which I'm aware. If every ballot were reviewed, that would be what we would call a hand count of the ballots. And Arizona law does not require that elections be tabulated by hand. Arizona law allows for machine tabulation. And Maricopa County, like every other county in Arizona, tabulates ballot by machine and does not review every ballot by hand, exactly as the law allows. Plaintiff seems to take the position that every ballot should be sent to adjudication, or at least these ballots should have been sent to adjudication. But again, that would be a challenge to the procedures, and it's too late to bring that type of a challenge in this election contest. Alternatively, plaintiff wants this court to determine voter intent of just these ballots, most of which just these ballots that were put into evidence. Now, there were 8 ballots in the exhibits that should have gone to adjudication pursuant to the policies and procedures that were established before the election. And the only proper role for the court in this election contest, if it's going to look at these exhibits, is to look at those ballots that should have gone to adjudication and determine at that point whether the adjudication board reasonably determined voter intent. You heard Mr. Jarrett testify that what he wanted to say and what he did say before Mr. Lasota objected, and then he changed his answer to fit with Mr. Lasota's question. But what Mr. Jarrett said was, had he been a member of an adjudication board, here's how he would have voted on that particular vote. And the reason he worded it that way is because adjudication is subjective. You have 2 people, you heard testimony, Your Honor, a Democrat and a Republican, looking at the ballot and saying, here's what we think it means. Here's what we think voter intent was. And if they disagree, a third person, a judge, is brought in. But it's a subjective process. And so Mr. Jarrett was trying to say, if I had been a member of an adjudication board, here's how I would have seen that. And you heard him say that if he had been a member of an adjudication board, he would have awarded 3 more votes to Ms. Hayes and no additional votes to Mr. Hamadeh, following the procedures that are laid out for adjudication boards. So when this court reviews these ballots, if it chooses to do so, that's how this court should approach it. First, should the ballot have gone to adjudication? If under the procedures it shouldn't have gone to adjudication, this court need do nothing more. If it should have gone to adjudication, then this court should ask, based on the procedures and policies in place for adjudication, did the adjudicators reach the right result? Just a few more quick points, Your Honor, and I'm done. As Mr. Barr said, illegal votes are not an issue here. That leaves misconduct or erroneous count. The county put on testimony regarding the procedures that we use and also testified that we followed those procedures, and plaintiff has not, to my knowledge, has not challenged that, and if he has, he hasn't challenged it seriously. Plaintiff did not allege or present any proof that the county's adjudication procedures violated existing law or rules. And in order to prove erroneous count, he has to demonstrate that. He has to demonstrate that we did something wrong. And that led to an erroneous vote count significant enough that Mr. Hamadeh should have won the election. And plaintiff didn't do that. Now, I say this as an attorney for the county. The county is not on either candidate's side in terms of who should be the next attorney general. But the county is on the side of this, Your Honor, and I'll close with this. The county conducted its election as it always does, in a way that was free and fair, and the election had integrity. And so we ask this court to rule against plaintiff in its challenge and confirm Maricopa County's election. Thank you, Your Honor.
Thank you, Mr. LaRue. Mr. Gaona?
Thank you, Your Honor, and thank you for your time this morning. I think if you ask anyone who knows me well, Your Honor, none of those people would say that I am at a loss for words very often. But the prosecution of this case nearly has me there. Plaintiffs filed a verified complaint saying that there was evidence sufficient for this court to take the extraordinary and unprecedented step of overturning the results of an election. An election, after all, Your Honor, that reflects the will of the people. It was a remarkable claim. But as the secretary told Judge Warner a month ago when this case was first filed, plaintiffs had no evidence, none, to support their remarkable claim. The secretary echoed this argument in her motion to dismiss filed here. And the court gave plaintiffs the opportunity to proceed to trial on 4 of their 5 claims. So here we are, Your Honor, the day of trial. Plaintiffs' chance to show this court and the public the evidence that they said existed under penalty of perjury. And what we now know is that this case was a spectacular waste of everyone's time. It was a waste of time to the county and the county's elections officials and their lawyers. It wasted the time of the secretary and her counsel. It wasted Ms. Mays' time. And most importantly, Your Honor, it wasted the court's time. This farcical proceeding has gone on long enough. Plaintiffs failed to carry their burden, and it's not even close. The secretary urges this court to hold as much, to confirm the results of the election, and to confirm that Ms. Mays was elected as Arizona's next attorney general, and to do so from the bench today, here and now. The people of Arizona deserve no less. Your Honor, I've had to say this far too often in the past few weeks in representing the secretary to defend the results of this election, but enough is enough. Thank you again for your time, Your Honor. We appreciate it.
Thank you, Mr. Gaona. Mr. Lasota, you get the final word.
Your Honor, may I just have 1 minute?
Who's this?
Mr. Jerkowitz from Pima County.
Oh, sorry, Mr. Jerkowitz. Yes, you may have a minute.
Thank you, Your Honor. Plaintiffs made allegations of misconduct, including inaccurate duplication against Pima County defendants in their complaint, which were unsupported by any facts whatsoever. A court-ordered inspection was done at county expense, and every examined ballot was determined to be accurate. After trial, plaintiffs have not presented any evidence whatsoever to support their allegations. Pima County defendants respectfully request that the court find that plaintiffs have failed to prove their allegations and render judgment in their favor and provide such other and further relief as appropriate. Thank you, Your Honor.
Thank you. Mr. Lasota?
Thank you, Your Honor. So I'll start with Mr. Barr and his about I don't know how many times he's accused me of unethical conduct in this proceeding, but largely it's another rehash of his failed motion to dismiss. I mean, the bottom line is in election contests, they're often not successful. They're probably unsuccessful. Well, I couldn't hazard a guess, but they're usually not successful. They have to be gathered very quickly under a very short amount of time with very imperfect information. And actually, I'll skip ahead to Mr. Gaona with his waste of time comment. I don't think that just because an election contest fails that we can categorically dismiss it as a waste of time. I think the election contest statutes provide a useful purpose, even if a case isn't always successful. We have a case here where it was decided by 511 votes. That's 0.02%, closest case in statewide history for a statewide candidate by percentage. And the notion that if you didn't prove it in the end, it was a complete waste of time and enough is enough. And we've had it with all these things. I think if enough is enough, I think they need to go to the Arizona legislature and tell them to get rid of the election contest statute. I think that obviously we asked for certain evidence that we didn't get. So, we're being attacked for not proving counts that we asked for production of evidence that never happened. So, and on that point, I mean, there's definitely a wide disparity in judicial rulings as to the applicability of the other civil rules, specifically discovery. I think some courts have said it's available, some it hasn't. That's a legitimate dispute. This court said it's not, and that's just the way it goes. So, I'll jump ahead to Mr. Barr's comments about the counts, and I'll just go one by one. So the check-in, check-out, the count one was a check-in, check-out procedures. I think everybody would concede there were, well, maybe not everyone would concede this, but there were problems in Maricopa County on election day. And what happened was you had people who went to vote centers who to vote, they checked in, and if you don't properly check out, which a number of people did not properly check out, when you go to the next vote center with less of a line, the machine says, oh, you've already voted. You're out of luck. Even though you didn't vote, you just checked in at another location. So those obviously were caused by the printer issue. We had, right off the bat, we had this printer issue where the printers weren't ready to print ballots that could be read by the tabulators. Now, again, and this is where we get into another misstatement by Mr. Barr about the misconduct we've alleged. Yeah, we use that word, misconduct. But we said in our complaint, we are not alleging any fraud, manipulation, or other intentional wrongdoing. So we did not allege intentional misconduct. And he continues to misrepresent our complaint in that regards. But the check-in, check-out, that was a big deal because you had voters who were denied their rights essentially because they weren't checked out properly. Now, I should rephrase that. They were potentially denied their rights. What the county did is they went, and it turns out they actually found most of the people who that applied to. I think they went outside of what their procedures say to do in that situation, but I think they did the right thing. They found the voters and said, you know what, this voter's vote should count in this circumstance. Now, that is something that we learned from Ms. Krager, and that was something that we had to run to ground. And we didn't find anything that would contradict that. So that is something that it turns out they actually went and they found those voters. That seemed to be at least not inconsistent with what we were able to glean. So I stopped talking about it. Count 2, the provisional voters, we never got the list. So I'm being attacked by Mr. Barr for not proving something, but we never got a list to match against our data. We do have declarations from people who said they weren't able, that their voter registration was canceled, who seemed to, we think, should have been able to vote. Count 3, I think, was the erroneous vote count. I think we did show some errors. They're obviously not substantial enough. We didn't go through all the ballots. We only went through some of them. And we were able to show what we were able to show. And in terms of, we also got to some adjudications, which count 4 dealt with, we thought, adjudication errors. And that in illegal vote, it didn't really allege a legal vote. It just, it was really erroneous adjudication. And perhaps that was a drafting matter that it could have been drafted a little bit better in retrospect. But I mean, that's just the way it goes in these types of situations. And that was only a heading anyway. That wasn't part of the body of the complaint. But adjudications, we did look at those to some extent, to the extent they were in the undercount. And the count 5 was dismissed. I think that is an illegal vote in terms of if the signature doesn't match, I don't think the vote should be counted, but that was dismissed on laches grounds. So at the end of the day, and I would point out that, last thing in terms of Mr. Barr is you heard Mr. LaRue said yesterday, he thought we had acted in good faith. We have tried to speed this thing along. We agreed to the motion to dismiss briefing, even though I think if we would have gone forward sooner, I think maybe our side would have benefited. We maybe would have been able to look at more ballots. But we agreed that they should have their shot on the motion to dismiss, and they failed. And now Mr. Gaona and Mr. Barr largely argue that motion to dismiss. Just a few points that has already failed, and is that that's the waste of time here, as they keep talking about that. So in terms of Mr. LaRue, I think he keeps going back to whether the county procedures were followed and suggests that that's the end all and be all of it. I mean, I understand they have their procedures, they're there, they're training, and they're there to basically process a large amount of votes and to determine, if you can't really tell, if the machine can't tell, then what should that vote be? I don't think that's the be all end all of everything. I think you've got I think that the question for this court under ARS 16-610 at SEC is whether we got the voter intent right. Never mind if it should have gone to adjudication or shouldn't have gone to adjudication. Undervotes don't go to adjudication typically. But that doesn't mean that they shouldn't be counted. When we look on the ballot and, hey, we got a check mark here. That's just the way this person does it. They put a check mark in instead of filling the oval. So I think that's the most important thing, is the voter intent. We get more hyperbola from Mr. Gaona about the, waste of everyone's time. We pled a complaint in good faith, and we made allegations, and we went about it with the materials we were given. This notion that it was based on nothing is just a complete falsehood. But as the court said, we are able to gather additional information as we go along. This is where we've ended up. I don't think it's a complete waste of time, because I think there's public value in having an election contest statute. And there could be public value in even having an unsuccessful election contest, because I think it gives the public a little bit more confidence that we have such a statute. Obviously, we wanted this case to go differently. We hope that certain developments in the case that we had no control over, including some of the discovery and things like that we'd get better access to the ballots. That didn't happen, but I think dismissing it as a waste of everyone's time, I think, does miss a little bit of a broader point. Lastly, Mr. Jerkowitz talks about the inspection in Pima County. I think we got to 160 ballots there. We had an unfortunate personal emergency with our inspector, and that was it. It's nobody's fault. It's kind of one of those things that happens in an election contest under compressed timelines. So I would just point that out for the court. At the end of the day, I think that, notwithstanding Mr. Gaona's demands that we do something from the bench here, I think we look at those ballots. I think we adjust the count. And obviously the other thing is we've got this statewide recount going on, which the legislature, they set the statewide recount at 12,500 votes, which is exponentially higher than our 511 vote margin. So that's the thing. We also have that going on. I think what this court should do is it should say how the vote should be properly counted, and that should be in its ruling. And I think that we would ask the judge that please count these votes, even if they didn't go to adjudication or didn't do this, and won't actually be enough to sustain this particular contest, because there were a lot of ballots we didn't get to examine. And with that, I would thank Your Honor for your prompt setting hearings and your attention and right before the holidays. So that is appreciated.
All right, well, thank you. I would thank all of you for all the hard work that's been going in over the last couple of weeks. And I know some of you involved in multiple cases at the same time in courts and other places, and people, not just the participants in this particular hearing today and the hearings that we've had in this case, but people around the periphery that have been working hard to get this to the court. The request that's being made today for me to count these 14 ballots based on their intent, while it sounds simple enough, it's just not how election contests should work. It's the court's opinion. I dismissed count 5 for a specific reason, that was kind of an attack on some of the processes in the election manual that's been in place for several years now, at least since 2019. The preparation of the election manual is something that's done above board, and people participate in that process, and there can be complaints about the manual, and maybe there will be in the future. But it goes for the same thing for recounting these ballots, these 14 ballots. That would be outside the processes that were put in place by the people that created these procedures. What would you are asking is, again, something I can't go back and rewrite the manuals, nor would I say they need to be rewritten. This is a difficult process. Doing an election is a difficult process, even in a small county like Mohave County. It's a difficult process. It's not a perfect process. It's an imperfect, but what you saw, and I think you saw this, Mr. Lasota, from the reaction while they fought some of your accusations, and sometimes it gets a little personal. But what you saw is when the reaction to them is get these information to you. I heard through the motions to dismiss and through this that this was an ongoing process to get information to you. You didn't get it as much information as you wanted, but there is information given to you about specifically count 1. You addressed it just now. I think count 2 was addressed in one of the motions to dismiss, where most of those ballots were people that registered after October 3rd and were not allowed to vote. Those are all things that have occurred because there's been some response by the county, Maricopa County specifically, to this process and to try to talk to you about it and give you information about it. This court has had to make rough decisions regarding the extent of discovery, and I ruled that based on this contested election and the process, it's very difficult to have a standard civil discovery process that we'd all go through. I don't know. I know all the lawyers know this, but normally if we have a civil trial, it gets filed in December of 2022, and it gets tried in January of 2025. That's how civil cases generally process through the system. This cannot be processed that way and has not been processed that way. The court granted your petition to inspect ballots. You conceded today that you got to inspect many more ballots than were inspected even in the other case that's processed, and I think that's a good thing. I'm glad that was able to happen. And again, Mr. LaRue was saying 24 hours ago that they couldn't even do that, and yet they did it. They got that done, and that's, again, a process to the response to the court's orders and to the requests here. What has ended up happening, however, is you just haven't proven the elements of the case as we review the record. There hasn't been proof that there's been mistakes made either, there's no allegation again. And I really compliment the plaintiffs in that regard, and I think I've done that before, both in writing and on the record. This isn't one of these cases alleging political coercion, isn't alleging incompetence or anything like that. It's just saying some mistakes were made based on some of these processes and that some votes may or may not have been counted. This hasn't been the type of case that sometimes comes before the court on these kind of procedures. The bottom line is you just haven't proven your case. You haven't met the burden. The mistakes that may have been made were not enough to overcome the presumption the court has to have in election cases. This is a contesting of an election that was done in early November, and it just doesn't overcome the presumption that the election was done correctly. There isn't enough information. I wouldn't even think there's even slight information that something was done illegally or incorrectly. They just follow the procedures, and this is the way it works out. And unfortunately, when all the ballots that I looked at would, for the most part, these 14 ballots would be voter error, not filling them out the way the instructions say. That could have fixed these problems, these minor problems that I saw in these particular ballots that counted votes against Mr. Hamadeh didn't get and Ms. Mays didn't get. Those are, if you look at those, there's mostly just people just not following instructions. And then there's the attempts, that the evidence is there's been attempts to correct when people don't vote right, to try to get people vote correctly. And there's been no evidence that that's been swayed one way or the other for Hamadeh or Mays. It's been the Maricopa County doing their job. And obviously we didn't get enough information, or maybe didn't get to dig deep enough. We found no information from Navajo County or Pima County that this court could even consider was done incorrectly. It is ordered finding that this petition is unsuccessful. It's ordered denying the petition to change the results of the election or even count any additional votes. The recount is underway, and that will be determined next week in court somewhere else. Obviously, based on some of the comments, I'm going to be seeing some future pleadings in this case, but I just want to address, if you need a written order, Mr. Lasota, I can probably get one of those out by sometime. I'll probably have to work Monday to do that, but I probably could get something out by Monday afternoon if you wanted a written order. But I am denying the petition and granting in favor of the defendants today, and not ordering that the election be recounted or any ballots be recounted based on the evidence that's been presented in this court. Mr. Lasota, a written order, do you need that?
Your Honor, I don't think we need a written order. No. And I mean, eventually, but I think eventually you'll do a written order, but I don't think you need to work on Monday to do that, Your Honor.
All right. Anybody else disagree with that? Seeing no hands. We'll stand at recess. Have a good Christmas, everyone. Thanks again.
Thank you, Your Honor. Merry Christmas to you.
Thank you, Your Honor.